In Prince Harry's major court case against the Daily Mail this morning, speculation the Duke of Sussex could settle out of court to avoid a public spectacle.
You didn't need to witness it in person to feel the impact. When legal documents involving Prince Harry began circulating among London's court reporters, the atmosphere changed almost instantly. The words on paper weren't about innocence or guilt. They were about exposure, risk, and cost. In the halls of London's courtrooms, those terms carry weight long before any judge even speaks. Insiders described the case as purely technical, while critics slammed it as reckless. Supporters argued it was a matter of principle. But behind closed doors, one concern overshadowed everything else: the fear that drawn-out litigation could trigger a tidal wave of legal fees. Figures not in the thousands, but in the millions, was palpable. Today, we trace the lawsuit, the hushed whispers, and the quiet math turning a legal battle into a looming financial cliff. The paperwork emerged subtly, almost deliberately, the way major legal trouble often does. A filing here, a date stamp there. Observant reporters at the Royal Courts of Justice noticed it before most editors even caught on. By the time the news hit the headlines, the narrative had already shifted. This was no longer about right or wrong, intention or principle. At this stage, it was all about vulnerability and the high stakes that come with it.
Our context, I emphasize, has almost every feature that has been identified as leading the courts to respect.
For Prince Harry, being sued changed everything. Starting a case is one kind of risk, but defending one is an entirely different challenge. Lawyers put it simply: when you're the claimant, you control the pace, the posture, the strategy. When you're the respondent, the clock belongs to someone else, and the costs follow that clock relentlessly. Those close to the matter described the suit as technical. Procedural arguments, jurisdictional questions, disputed responsibilities. On paper, it's hardly dramatic. But in practice, the impact was immediate. Mounting a defense requires teams, teams require time, and time, inevitably, invoices itself. Soon, court reporters began reaching out to sources with a single pressing question: how big could this get? The answers were measured, careful, but unsettling. High-profile litigation in London does not move fast. Motions spark countermotions. Disclosure widens. Expert opinions multiply. Even before a judge weighs in on the substance, the meter is already running. Legal analysts were quick to clarify: this doesn't suggest guilt or an impending loss. It signals exposure, vulnerability, and risk. Inside newsrooms, editors noticed the shift immediately. Coverage began to move from motive to math, from why this was happening to how much it could cost. That pivot is decisive because it changes the way every development is interpreted. A filing is no longer just a procedural step. It's a dollar figure, ticking upward with every page, every signature, every hour.
But it's involving some big heavy hitters as well. We've got Sir Elton John, his husband David Furnish, the actor Liz Hurley involved, as many others as well. So, will Harry go through with this? It's listed for 9 weeks, can you believe?
The tension was immediate, almost palpable. Every recent appearance by Prince Harry was replayed under a new lens. Was his return to the United Kingdom a matter of choice or necessity? Was his presence strategic or simply unavoidable? No one offered answers, and that silence only fueled speculation. Behind the scenes, advisors were weighing every option: settle early and absorb the hit, or fight and risk escalation. Neither path promised relief. Lawyers explained it clearly: settling can limit exposure but invites interpretation. Fighting can vindicate but drains resources. Once litigation deepens, there is no clean lane. Inside Buckingham Palace, that reality split opinion. Royal correspondents with long access report that 2 camps emerged. One argued the institution must remain entirely distant. Legal battles were private, with private consequences, and any hint of involvement would blur boundaries. The other camp worried about optics. A senior royal facing potentially massive legal bills without visible support risked appearing isolated. In the end, distance prevailed, but it carried weight. For Meghan Markle, the lawsuit unfolded mostly off-camera. She did not appear at the court steps. She did not comment. Analysts and insiders filled the silence with conjecture, late-night calls, strategy debates, and the strain of watching legal costs climb while outcomes remained uncertain. None of it was confirmed, but all of it felt plausible. Concrete details only amplified the pressure. Legal calendars stacked dates across weeks, disclosure deadlines, preliminary hearings, and the looming possibility of appeals. Each date became a marker on a rising graph of tension and expense. Commentators stressed that even procedural victories cost money, and even delays were expensive. Visuals reinforced the shift in mood. Rain slicked the stone steps of the High Court. Lawyers moved briskly, files tucked under arms. Harry arrived and departed without comment. The images carried a different energy than earlier litigation stories, less defiance, more endurance. On the streets of Britain, reactions were mixed. Some expressed sympathy, framing the suit as another example of relentless scrutiny. Others questioned judgment, asking why so many legal battles were being fought simultaneously. Stories of money, after all, strike a chord because they touch real-life experience.
Of Harry, a YouGov poll this week shows that Harry's popularity has sunk following his BBC interview. Hardly surprising.
The online conversation hardened quickly. Speculation about Prince Harry's legal bills went viral. Threads, estimates, and repeated numbers exaggerated totals until millions in legal costs became the lens through which every development was viewed. On one side stood Harry's determination to confront what he saw as wrongdoing. On the other stood a system indifferent to motive, methodical in procedure, and relentless in cost. Time quietly inflated the stakes, turning routine filings into pressure points. Financial commentators tried to add nuance. They explained that lawsuits do not automatically mean ruin, that wealth structures are layered, and exposure is not an outcome. Yet nuance struggles in a world driven by fear. Once a cost narrative takes hold, it becomes self-sustaining. Even favorable rulings struggle to undo weeks of arithmetic-driven framing. Silence from those involved preserves legal strategy, but it surrenders emotional ground. Without clarification on funding or contingency planning, the public imagination filled the vacuum, creating its own narrative. As the case unfolded, the questions changed. Court watchers no longer asked what the case meant, they asked how long it could last. Duration, not outcome, became the pressure point. Every procedural step, motions, disclosures, expert reports, added complexity, demands, and inevitably cost. For Harry, this wasn't just a legal challenge, it was a posture. Defense requires teams, preparation, and endless hours. Even strong cases bleed money over time. The danger isn't one dramatic bill, it's the accumulation that creeps quietly, week after week, hearing after hearing. Inside Buckingham Palace, advisors debated the approach. One faction urged strict non-engagement to protect institutional boundaries. The other worried that the optics of distance hardened into a narrative of isolation. Distance held, amplifying the human drama. Every appearance, every expression, every exit became material for speculation. Was Harry resolute, fatigued, guarded? For Meghan Markle, the case remained unseen yet present, shaping scheduling, travel, childcare, and security behind the scenes. The antagonist had shifted. It was no longer just an opposing party, it was the system itself. Courts do not care why you fight, they care that you follow procedure. Procedure charges a toll. Media coverage mirrored this indifference, shifting focus from claims to consequences. Even procedural victories were framed as temporary reprieves, not progress. Exposure overshadowed principle. Fear compressed complexity into a single, tangible image, a cliff edge visible to all. Visuals reinforced the story. Nighttime shots of the royal courts, lights burning late, lawyers moving briskly, Harry exiting without comment. Studio debates emphasized risk. Behind the scenes, lawyers explained when cases tip from manageable to consuming. It's not when a judge rules, it's when preparation for the next step eclipses everything else. Planning becomes reactive, time becomes scarce, and clients begin asking a different question. Not whether they are right, but whether they can endure. Even as procedural wins occurred, the narrative hardened. Exposure, duration, and pressure became the lens through which every update was read. Litigation transformed from a means to an end into an environment demanding continuous resources. Every court appearance was measured in cost. Silence spoke loudly. Resolve became a variable. Principle became a line item. By the time Harry returned to the United Kingdom, the stakes had shifted further. It was no longer just a procedural necessity, it was proximity to the meter itself. Every interaction, every absence or presence, every expression was contextualized by cost. The story revealed less about law than about perception. Once a lawsuit is understood primarily through its price, every choice is judged against sustainability. Endurance became the story itself. Court cases are decided by judges. Court costs are decided by time. In this extended phase, court watchers stopped asking who would prevail. They asked who could last. Each procedural conference gave way to disclosure battles. Each disclosure birthed expert reports, and each report invited challenges. Every layer added complexity, and every layer added cost. None of it signaled weakness, it signaled gravity. For Harry, gravity carried a personal edge. Being sued placed him in a posture that demanded constant response. Silence is expensive. Preparation is mandatory. Even brief hearings require surrounding work. Lawyers prepare for contingencies that may never materialize because the price of being unprepared is higher. Costs compound in three ways: time spent, specialists retained, delays incurred. The danger is not a single dramatic bill. It is accumulation, quietly advancing until it becomes visible. Inside Buckingham Palace, advisors understood the reputational implications even as they held their line. Institutional distance protects boundaries but leaves a vacuum. The public imagined scenarios, some sympathetic, some unforgiving. Commentary hardened. One side praised restraint, the other warned that isolation was becoming entrenched. A senior royal facing mounting legal exposure without visible backing invites interpretation, fair or not. Human drama filled the gaps that facts could not. Analysts speculated on decision fatigue, endless meetings, nights ending with the same unanswered questions. When do principles stop being abstract and start feeling heavy? For Meghan Markle, the case remained an unseen presence shaping coverage. Analysts spoke about shared risk, the strain of watching litigation escalate while outcomes remain distant, and practical realities rarely mentioned on air. Scheduling, childcare, security, travel, the friction of a life interrupted by court calendars. The antagonist was fully formed, not just the opposing party, but a system indifferent to motive. Courts care about procedure, not principle. Procedure charges a toll. Media language reflected that. Headlines pivoted from claims to consequences. Even positive rulings were framed as partial or limited reminders that relief in court does not always translate to relief on a balance sheet. Online discourse accelerated again. Threads attempted to reverse engineer totals, drawing comparisons to unrelated cases, rounding numbers upward because round numbers feel truer. None of it was verified, but repetition made it feel real. Financial commentators tried to slow the cycle, explaining that exposure does not equal insolvency, that costs can be staged, and that outcomes can mitigate damage. Their caution was accurate, but outpaced. Fear compresses nuance into a single image. Once that image exists, every step appears to edge closer to the cliff. Visuals reinforce the compression. Evening shots of the court with lights still on, Harry exiting with shoulders squared, expression neutral, palace gates closed. Studio debates highlighted risk. Behind the scenes, lawyers described the tipping point. It's not when a judge rules, it's when preparation for the next step consumes everything else. Planning becomes reactive. Time is scarce. That is when the question changes, not whether you are right, but whether you can keep going. Palace advisors monitoring the narrative worried about durability. Cost stories linger. Even if a case resolves favorably, weeks of exposure framing attach themselves to future coverage. No statement arrived to interrupt the arc. No reassurance reframed the stakes. Silence continued to serve both legal caution and narrative risk. By this phase, the story no longer required new filings to progress. Each mention invoked the same themes: exposure, duration, pressure. Litigation was no longer a series of events, it was an environment, one demanding continuous resources without sentiment. For Harry, return to the United Kingdom carried a different weight. Every appearance was contextualized by cost. Silence spoke loudly. In the end, the story revealed less about law than perception. Once lawsuits are understood primarily through their price, endurance becomes the story itself. Resolve becomes a variable. Principle becomes a line item. And as the courts slowly continued their work, the lingering question was not who would win, but what victory would cost by the time it arrived. Court cases are decided by judges. Court costs are decided by time.